Measure number 112. Result of a yes vote. Yes vote amends Constitution to remove language allowing slavery and involuntary servitude as punishment for crime. Allows programs to be ordered as part of sentencing. Result of no vote. No vote retains current language that generally prohibits slavery and involuntary servitude but allows slavery and involuntary servitude as punishment for crime. Summary. Amends Constitution. Article 1, Section 34 of the Oregon Constitution currently prohibits slavery and involuntary servitude but allows an exception for that prohibition as a punishment for crime. Measure removes language that allows slavery and involuntary servitude as punishment for crime. Under measure, a court or probation or parole agency is allowed to order a person convicted of a crime to engage in education, counseling, treatment, community service, or other alternatives to incarceration as part of sentencing for the crime. Ordered programs must be in line with programs that historically or in the future have been in place to provide for accountability, reformation, protection of society, or rehabilitation. Effect on current constitutional provisions requiring inmate work programs unclear. Estimate of financial impact. The financial impact to state and local expenditures and revenues is indeterminate. The measure removes language allowing slavery and involuntary servitude as a punishment for a crime. The measure does not require additional state government revenues or expenditures. However, the impact of the measure will depend on potential legal action or changes to inmate work programs. Text of measure. Whereas the Oregon Constitution has prohibited slavery and involuntary servitude, which is the coerced service of one individual for the benefit of another, since 1857, and whereas the Constitution's prohibition on slavery and involuntary servitude contains antiquated language that on its face creates an exception to the prohibition on slavery and involuntary servitude, and whereas in a just society that respects human dignity and exercise of free will, there must be no exception to an unqualified and absolute prohibition on slavery and involuntary servitude, and whereas Oregon and the United States are examining past instances of discrimination and are striving to undo fundamental and historical barriers that perpetuate the injustice and unfairness of discrimination, and whereas a state constitution is a foundational element of governance in a civil society and therefore no place for remnants of historical language that perpetuates principles of discrimination and racial intolerance, and whereas the voters of the state recognize in adopting Section 41, Article 1 of the Oregon Constitution, Section 41, that individuals who are convicted of a crime benefit from being fully engaged in productive activity so as to successfully re-enter society with practical skills and viable work ethic. And whereas Section 41 envisions persons who are incarcerated performing labor at correctional institutions or pursuant to work release programs, participating in training and participating in educational opportunities, all of which develop motivation, work capabilities, and cooperation. And whereas Section 41 authorizes compensation for labor and describes several types of jobs or related training that those who are incarcerated may perform. And whereas because work provides myriad individual and collective benefits, the purpose of this proposed constitutional amendment is not to withdraw legitimate opportunities to work from individuals who have been convicted of a crime. And whereas Section 41 of this proposed constitutional amendment may operate in tandem to achieve positive outcomes for persons who are incarcerated or who re-enter society while more fully and completely removing the stain of slavery and involuntary servitude from the state. Now, therefore, be it resolved by Legislative Assembly of the State of Oregon, Paragraph 1, Section 34, Article 1 of the Constitution of the State of Oregon is amended to read, Section 34. There shall be no slavery or nor involuntary servitude in this state, taking out the state otherwise than as punishment for crime thereof, and the party shall have been duly convicted. Adding number 2, upon conviction of a crime, an Oregon court or a probation or parole agency may order the convicted person to engage in educational counseling, treatment, community service, or other alternatives to incarceration as part of sentencing for the crime, in accordance with programs that have been in place historically or that may be developed in the future, to provide accountability, reformation, protection of society, or rehabilitation. Paragraph 2. The amendment proposed by this resolution shall be submitted to the people for their approval or rejection at the next regular general election held throughout the state. Explanatory statement. Ballot Measure 112 amends the Oregon Constitution to remove an exception to the prohibition against slavery and involuntary servitude for punishment for crime. The Oregon Constitution currently prohibits slavery and involuntary servitude, but permits slavery and involuntary servitude as punishment for a crime. Ballot Measure 112 removes all language creating an exception and makes the prohibition against slavery and involuntary servitude unequivocal. Ballot Measure 112, Section 34, Subsection 2, would work in tandem with Section 41 of the Oregon Constitution, which establishes work requirements for adults in custody and is not intended to repeal that section. Ballot Measure 112 permits a court, probation agency, or parole agency to order a person convicted of a crime to engage in education, counseling, treatment, community service, or other alternatives to incarceration as part of the sentencing for the crime. The education, counseling, treatment, community service, or other alternative to incarceration that is ordered must be in line with programs that historically or in the future provide accountability, reformation, protection of society, or rehabilitation.